star.
True.
Yeah, thank you.
It's true, but we're also live now.
Public know you're awesome.
All right, and with the announcement that Dylan Goldberg is awesome, we begin the voting session here for the House Judiciary Committee. It is March the 9th, 2022. We will not be voting on Dylan Goldberg being awesome or not tonight. And it's not a judgment. We're just not doing that right now because it's 7:45. All right. So we have a bill that has been withdrawn from Delegate Kipke. It's House Bill 810. It's withdrawn. Could I get a motion?
Move unfavorable.
Motion for an unfavorable. Is there a second motion? Moved and seconded for an unfavorable withdrawn. All in favor, raise your hands. Yeah, that's everybody. Anybody opposed to the unfavorable withdrawn? Seeing none. All right. 810 is withdrawn. So now we're on House Bill 284. This is Delegate Crutchfield's bill. There is an amendment. Delegate Crutchfield or Council, well, Delegate Crutchfield, we'll go to you. Can you tell us what the amendment does, please?
Yes, it's technical. So what it does is just add in witnesses. So this is a hearsay exception that applies to victims of neglect and also victims and witnesses of violence, acts of violence. So that's what it expanded to that. And that's what the amendment does.
That's fine. And this is amendments, that's 563-529. Let me get a motion on the amendment. I know Delegate has a question. There's a motion for the amendment. Second. All right. So now we're on discussion of the amendment. Delegate Arakan, please.
Thanks, Mr. Chair. So I was just reading the Bar Association's comments. Does this amendment fix what they were worried about or not? Because I think they wanted that part removed, but it sounds like you're adding it.
You know what? I don't remember what their issue was, to be honest with you.
Let me see if I have it.
So
here.
let me find it real quick. Yeah. So they're talking about removing the language about crimes of violence. So no, we did not remove that.
Okay.
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 So what we're saying is that this is an exception for witnesses, child witnesses, child victims of crimes of violence. So
okay. So, but not so that, so, but all and neglect is already in code.
No, and neglect okay. for child victims. Okay.
Okay. So, and then, so for the alleged perpetrator, would they have access to is it required to have video or audio recording? How would they dispute something if they felt that they needed to?
Well, what usually happens is there's a hearing. There usually is a hearing so in other words, if the state's attorney wants to use this information, then they will alert the defendant who, as you mentioned, might be the perpetrator. And that person then has an opportunity to depose the person that our child has made their statement to. Okay.
Okay. So there's like third party.
Correct. Because that's what this is. This is an exception saying that the child does not have to be in court to say, or, their statement will be used. Okay. Because it'll be admissible without them being there because the child has gone through some form of trauma, most likely. Right. When this has happened. And it doesn't, they don't use it all the time, but that's what this is designed to do, to eliminate the trauma, to eliminate the child being in the courtroom and having to relive what they went through.
Yeah, that's horrible. So I just want to understand it. The child will disclose to somebody, would there be more than one witness? Like, I'm just a little worried about the situation where it's kind of like one person saying what a child said, you know what I mean? And then there's not documented.
Okay, so let me go through it then, okay? So the child makes a statement to maybe a psychologist or psychiatrist or someone, right, who's a trustworthy, I'll say, person, okay? That person then says, this child says that they've been abused. And so now the state's attorney wants to make sure that child is no longer in that environment of that abuse. So they say to the court, this is the problem, and then notify that person that's being accused of the abuse. And that person can now, through their attorney, actually come in and, ask for a pretrial hearing to understand what that statement was, okay?
Okay.
And then the court decides whether that statement is really a statement that's trustworthy. That's, there's a whole lot of different factors to determine whether that's something that should be used in court or not.
Okay. So it would be like where the child told the parent and then the parent is that third party, or is it usually
Well,
like
it's
a
usually
therapist
someone
or
else,
something?
right? It's usually someone else, social worker, someone else. It's not usually the parent.
Okay. Thank you very much.
Sure.
And to be clear, it's further in the existing statute, the state has to provide an intention to use the statement and basically say, we're giving you fair warning that we're going to use a statement of an out of court statement from a kid, and you're going to have the ability to question effectively the veracity of that in a motions hearing. So that's prior to the trial date usually, and it has to be 20 days before the criminal proceeding in which a statement is to be offered into evidence. So they've got to have, 20 days before the trial date, 3 weeks, they've got to have a hearing beforehand, which then gives the defendant, I guess, the opportunity to defend. I don't think I've got that wrong, Delegate Crutchfield.
I don't think you do either.
All right, first time.
Thank you.
All right, Delegate McComas.
I know Doyle, okay, and he's works for the Prince George's State's Attorney's Office. Okay, he's saying that he's concerned that it doesn't meet, that if we include the violence, it doesn't meet the right to confrontation, and it's not constitutional. Now, I know when I was on the committee with Valerio, I mean, that was kind of like drilled into our little heads, the right to confrontation. So my question is, will this meet the right of the defendant to confront his witnesses by having that hearing to see if the child's reliable and the statements are reliable? I don't know the answer, so I'm asking.
Right. So according to the state's attorneys, at least in Montgomery County, is my understanding that that's enough, that, the hearing, that they actually provide enough that person, like you said, we can get beyond the constitutional requirements of confrontation because they actually go through that pretrial hearing that our Mr. Chair just described. And that's what they explained to me.
But has that ever been litigated?
I personally don't know that, whether it has been, and unfortunately, I guess I could find out.
No, I'm just I'm just wondering if, because I forget what child, but it was just drilled into my brain.
Right. And during that so another part of it is the child will be cross-examined, as Mr. Chair mentioned as well. That's a possibility too, by the court, to see and confirm that statement, how it was made. Was it made under duress? Was it made out, what I mean? To make sure the truth and veracity of that statement.
So, and again, I think the point is that the motions hearing, while it's still open to the public, it's different than if it were in front of a full jury or something like that. So my understanding, and Delegate Crutchfield can correct me again if I'm wrong, but understanding is that the child could still get cross-examined at that point in the motions hearing. So it just allows that statement to come in outside of, it allows the statement to come in into the trial because it's been kind of verified outside of the trial. Am I right?
Yes, I think that's absolutely right.
Delegate Cox.
Thank you, Mr. Chair. I'm just joining in there with the Sixth Amendment concern. I think when you look at the bill and you look at the concerns, the right to confrontation is shaky in this bill. And if you can imagine, this could actually, this is expanding to child witnesses of all violent crimes. So that could be problematic, I think, when you go to try to ascertain how this child became a witness. Certainly there should be safeguards and guardrails as the law tends to protect children in how the cross-examination may be performed. However, this
Mhm.
bill doesn't require that. And there's a violation, I think, in that there's a way to convict people now with never, ever having the court had an opportunity to actually have the witness be confronted or in any context. It's a complete hearsay. So I would just say, under the Sixth Amendment, it says, in all criminal prosecutions, the accused enjoys the right to confrontation. It says to be confronted. So that's my explanation of why I'll be voting no.
Okay, and Delegate Cox, if you look, in fact, to the fiscal note on page 3, you'll see all the factors that are used to determine whether that child statement is in fact admissible. Okay, so there are your guardrails and your guidelines on what's admissible and what will be brought into court.
Right. And thank you, Delegate. I did read those, and I think that the subjective nature concerned me because, again, this is all hearsay. I mean, in fact, one of the factors is to weigh the credibility of the person, the third party, the hearsay person making the statement, and that's concerning because now you can have a whole hearing about a hearsay credibility person, and that's just not. I don't think it's a good bill for that reason. So. As much as I appreciate you, Delegate, protecting children, I'm all for that. I think the protection comes in. I think the ultimate protection would come into making sure we keep the Sixth Amendment right to confrontation within the guardrails.
And I was pretty certain we were doing that.
Yeah.
So I with all the factors, with all the pre-trial hearing, all of that, to make sure we're actually doing that. But I appreciate your comments, Delegate.
Delegate Juanita Fisher.
I was going to move favorable or move to previous question, Mr. Chair.
I understand. We're on the amendment, so let's hear from Delegate Grammer, and then we'll move the amendment. Delegate Grammer.
I just wanted to make note that we had addressed a similar bill when the state's attorneys came to us and said they had problems procuring witnesses. And they wanted to expand the hearsay exception. We passed a very similar measure. And I think, within the bounds of the criminal procedure article, it's fairly reasonable to make exceptions like this when you have people that frankly aren't going to make a statement because they feel they're under duress. So it's something we've done. It's something we've explored fairly thoroughly in this committee. I think it's fairly reasonable, and it's something we've passed, I believe, in the last 4 years. Thank you, Mr. Chair.
We're on the amendment. So again, the amendment, as I understand it, Delegate Crutchfield puts it in alignment with the way the bill left the Senate, correct?
That is correct.
All right. There's been a motion and a second on the amendment. All in favor of the amendment, please raise your hands and I'll call names as we go along. Delegates Fisher, McComas, Bartlett, Anderson, Lopez, Erican, Shetty, Munoz, Moon, Davis, Howell, Jones, Tolles, Shoemaker, Crutchfield, Cardin. Anyone opposed to the amendment? Seeing none, the amendment is adopted. We're now on the bill.
Favorable.
Motion for a favorable on the bill. Second. Is there further discussion on the bill? Roll call. Delegate Erican.
I just wanted to say I pulled up the vote count from the Senate and it was unanimous on the floor.
Okay. Anyone else with comments, questions on the bill? Delegate McComas waving her hand. We're going to figure out how to use the electronic version.
Okay,
Yeah.
question. Have any other states done anything very similar to this? Just wondering, that's all. And if you don't know, that's fine too, but just.
I think they have a Delegate McComas, and I think you asked that question before, because I have that written down. So that's why I know they have, but I don't remember what states.
No, that's fine.
And I don't remember how many. I don't have that written down.
But in other words, we won't be the first, and so.
Yeah, I don't
we
believe
we
that's
think
the
this
case.
is past muster in other states, the confrontation issues. So, okay, all right, that's all I needed.
Any other questions?
Just
Delegate Carden, go ahead.
thank you, Mr. Chair. Just comment that having also read the State Bar Association's comments, maybe I think this is a great bill. I just think that if there are constitutional issues, which they say there could be constitutional issues with including crimes of violence, that we may need to revisit this another time, and we can talk about that, Delegate Crutchfield, if necessary.
There's been a motion and a second. We'll go to a roll call here. The Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett, No.
Oh, yes, you couldn't hear me. I'm sorry. Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Davis,
Yes.
Wanika Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Jones,
Yes.
Lopez,
Yes.
McComas,
Yes,
Munoz,
Yes.
Shetty,
Yes.
Sham,
Yes.
Tolles,
Yes.
Williams.
Yes.
That's 20-1. So that's favorable with an amendment. All right, let's keep going. This is House Bill 296, which seems to have had some renovation with an amendment being offered by Delegate Crutchfield. We'll let Delegate Crutchfield describe what this amendment does. This is the amendment with numbered 153726. 153726.
Yes, it's a long amendment, and that's because the entire bill has been renovated, as you mentioned earlier. And now it now serves a purpose of just providing temporary protective orders, and only in hospitals, and let me just make sure I got the wording correct, on locations such as domestic violence assistance locations, sexual assault prevention or assistance programs, et cetera. Those are the places where they can now do an electronic filing for protective order. And it is also during business hours when the court is actually open. So those are the big amendment changes.
I have a motion on the amendment.
Move favorable.
Favorable.
There's a second. There's a second. All right. We're on the amendment. We'll hear from Delegate Bartlett, then Delegate Anderson.
Okay. Delegate Crutchfield, talk to me about this business hours part. Can you
So
just
that
talk to
was sort of
a little bit?
a compromise with the courts because they felt concerned about allowing the protective orders to be outside of business hours, which meant that folks could actually be connected to a commissioner. So there's concerns with those, commissioners who may be in rural areas and getting in touch with them, et cetera, et cetera. So that's why it is now under the business hours of the courts.
Quick question though. So aren't the commissioners around 24 hours?
They're supposed to be. That is absolutely correct.
Oh, okay. So maybe those are the business hours that they're talking about, the 24 hours. I don't know. Anyway, okay.
No,
I'll
I
leave
can
it.
tell you, those are not the business hours.
I know they're not. I know they're not.
wanted
Okay, well, I mean, I want the
exactly.
bill to move, and I understand compromise, but I don't like the business hours portion. I don't like it, but anyway,
and then,
that's it.
yeah, and the other thing is that it's very similar to what's done in Montgomery County with our family domestic center, which does, protective orders. And again, it's during business hours. It's when the court is there, so that it's a direct link with the court versus dealing with your commissioners, et cetera. The court had some concerns about whether, people will get the help they need if it's a direct line to the commissioners. So that's why it is now positioned the way it is.
Delegate Anderson.
Yeah, thank you, Mr. Chairman. Delegate Crutchfield,
Mhm.
one of the concerns that I had on the original bill, and I'm going to ask you if the amendments fix this, but on page 2, line 11 on the original bill, where it says the hospital or urgent care center may, but is not required to allow an individual to file a petition electronically. Why, I mean, has that language been removed? Or in other words, why wouldn't we just say a hospital? Now I know you took out urgent care and you added other places, but just for the sake of this argument, why wouldn't we just say a hospital may allow an individual to file a petition rather than saying that it's not required to allow it?
Well, I think we're talking about the same thing. Because what we wanted to make sure of is, and what we heard from the hospitals is that there are instances where there may not be staff there to help someone do this. So we didn't want to force the hospital into a situation where someone comes in and says, I got to get this done. I need, immediate help, etc. So, that's where the may came in. They may assist, they may, but so I think it's more semantics.
But my concern is, I agree with the may, but what I don't like is, but is not required to.
Correct.
In other words, not required to allow it. Why would the hospital have any reason not to allow it?
Because there are hospitals that again felt like they didn't have the staff or the people that were able to provide assistance. And that's really what it was.
Okay, well, bottom line, this is a teleconference, video conference, whatever. I know we had discussions about whether or not hospitals could provide these facilities or not for folks who were indigent, who might not have been able to do it on their own. But the simple act of allowing it or not allowing it, I think is dangerous to the bill, because there may be other reasons or other motivations by the hospital not to allow it. Like in case it's one of the hospital staff members that is being complained of.
Yeah. Well, I'm understanding now, I have not really checked in my community, but I do understand there are some communities where they actually have a direct connection with some of the organizations, some of the domestic violence organizations. And so when someone comes in, they automatically check with that person to see what their needs are, which include, do they need a protective order? And then they can dial, that organization in and really assist. But there are hospitals that just don't do that. They don't have that means or availability. So instead of forcing all hospitals to do this, this was.
Yeah, but I don't think, I think the word may solves that problem. That they may do it. They don't have to, but they may do it. Okay. That's what may means.
Right.
You put in that they shall do it. But then when you put in that they may, but are not required to allow, I think it lets the hospital know, well, we don't really have to allow this.
Mr. Chair, I've just gotten notice from some of the folks who help with the drafting that the line that Delegate Anderson is talking about, the is not required to, has been amended out. So I think that your question has been answered.
Yeah, I kind of wondered that too. There were significant changes made to that part of the bill. The Delegate Crutchfield, can you just confirm that and maybe that addresses Delegate Anderson's point?
Okay, so there's somebody else who's just as smart as me.
No one could be that smart.
My man. All right, I'm sorry I wasted everybody's time.
No, you didn't waste any time.
You're never a waste of time.
Okay. All right.
Before this gets weird, Delegate Erican.
Thanks, Mr. Chair. So, that definitely wasn't a waste of time because
no, it's important.
Yeah, really important.
Yeah, I agree.
So, I'm super uncomfortable and would love confirmation as to whether or not the hospitals are still retaining some kind of discretion. If they are in the final draft, what kind of discretion exactly is it? Is it that the hospital does not have to do it at all? Or is it that they can make a choice case by case if they're going to allow access? In which case that's a whole other problem. That leads to very subjective,
Okay.
application.
So I just got confirmation. Yeah, that part is taken out and I'm trying to just look at it. Yes. Yeah.
Who's counsel for this bill, Lauren?
Yes, and so the new language reads, a petitioner may file electronically a petition for a temporary protective order with the court from a hospital where the petitioner is receiving medical treatment while the petitioner is at the hospital.
Oh, okay.
Right.
Okay, so the part about the hospital not participating is out.
That is
Part
correct.
that was, yes, the part that said may is not required to is out of the bill.
Great.
Mhm.
All right, still
Move
on the
favorable.
amendment. Any
Move favorable
questions?
as amended.
All right, hang on. We haven't actually passed the amendment yet. Let's do that.
Sorry, Mr.
Do you have
Chair.
a motion? That's okay. Motion and a second on the amendment. All in favor of the amendment, please raise your hands. I see Anderson, McComas, Erican, Cox, Fisher, Grammer, Lopez, Cham, Davis, Moon, Munoz, Shetty, Shoemaker, Williams, Tolles, Jones, Howell, Hardin, Crutchfield. Anybody opposed? Seeing nobody opposed, the amendment is
Move
adopted. We're on the bill as amended. There's a motion for a favorable. Is there a second?
Second.
And a second. Further discussion on the bill as amended. Right. All right, we'll do a roll call. The vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett. As away from her chair. Carden,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Winika Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes, sorry, I thought I unmuted. I apologize.
that's all right, Tolles,
Yes.
Williams,
Yes.
Bartlett.
Yes.
All right, 21. Okay, we're moving right along. We're going now to 349. This is a bill that we passed last year.
Move it.
And I think it's without amendments. Yes, no amendments. There's a motion on the bill.
Move favorable.
Motion for a favorable. Is there a second?
Second.
All right. Discussion on the bill and the motion for favorable. The vice chair.
Mr. Chair, I just want to remind folks that there was a bipartisan vote on this bill last year, and the creditors bar also supported this. So I hope for a strong favorable on this.
Delegate Erican.
Sorry, this was the HOA one where the poor woman was arrested because of her flipping HOA fees.
Correct. It's about stopping people from being arrested over amounts in controversy under $5,000 in small claims court.
Yeah. All right. Thanks.
Okie dokie. Any further questions? Seeing none, the vice chair,
Yes.
Shoemaker,
No.
Anderson,
All right, strong favorable. Is that good? Good enough, David?
is that your vote or your vote?
Yes, strong favorable.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Winika Fisher,
Yes.
Grammer,
Yeah, yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas. Sue?
No, I don't think I voted for it the last time. I was looking. No.
Okay. Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams,
Yes.
19-2. Apparently my voice,
Strong favorable.
that is strong favorable. All right, well, let's see about this one then. This is 441. There is an amendment as a questionable sponsor, I guess, but the amendment is in your packet. The bill as initially introduced would have required the state's attorney's office in the court to provide notice to the police department when someone was released on pretrial supervision for certain crimes of violence. This changes it. The amendment is 663923. It amends it. It changes the courts and the state's attorney's office to the Department of Public Safety and Correctional Services, and it limits it only to Baltimore City. So the idea is to set up effectively a Baltimore City pilot for this. And the information is released to the Baltimore Police Department. That's what the amendment does.
Move favorable on the amendment.
Motion for a favorable on the amendment. Is there a second?
Second.
Thank you. Any discussion on the amendment? Delegate Carden?
Thank you. Just to make sure, I think it's a great bill and I love it. Are we going to get in trouble if we don't have a Baltimore City letter because it's become a Baltimore City bill? I just want to make sure. And if not, I don't think we need it, but I just.
I don't know that we necessarily needed it at this point. I think that I don't think we needed it at this point.
I would agree. I just want to, in case there's an issue, I just put it out there.
I understand.
I think in light of the fact that the mayor of Baltimore City came and testified along with the commissioner, probably would alleviate the necessity for that.
That absolutely means nothing.
Frank has spoken. The Delegate Conway has spoken. I apologize, Delegate Conway. Look, I think, the idea here is seeking to address an issue that in fact the mayor and the police commissioner did bring forward. But Delegate McComas on the amendment.
Mr. Chair, my only concern is that basically we're cutting out the court and the office of the state's attorney, which is in Baltimore City, okay, and putting in the Department of Public Safety and Correctional Services to notify the Baltimore Police Department. Well, it would seem to me that there would be a closer relationship between the state's attorney and the Baltimore Police Department, but I don't know. And so I'm a little concerned about that. And then the other thing is we basically, a guy could be put in jail for, let's say, vagrancy 4 or 5 times, and they're going to release him, recog him. And so the Department of Public Safety is going to have to be notifying everybody that the guy's booked, that the guy got let out.
Let me start with the second part.
Because we eliminated all that other stuff.
This only deals with crimes of violence, and it only deals with specific crimes of violence and for which someone has been released pre-trial. And those crimes are murder in the first degree, murder in the second degree, attempted murder in the first or second, robbery with a dangerous weapon, or armed carjacking. So it only addresses those crimes. It doesn't address.
Excuse me, that's out of the bill.
Oh, is that out of the bill now? So now it's.
Yeah, it applies to all crimes.
Okay, well, there's an issue then. What question do you have, Delegate McComas?
Well, but just what I said, if the little petty ant misdemeanor versus and I was kind of concerned because it didn't mention the serious stuff that you really want to get at. And so
Well,
it just opens the universe.
now, as it was
That's what you want.
introduced, it was just those specific things.
Well,
Now
they're
it reaches
crossed
to
out.
all of it. Yeah, it reaches to all of it. I think
There's a
there's-
reprint on pages 9 and 10 of the packet.
And that's what I'm looking at.
So the main idea, I think, here is that the Department of Public Safety and Correctional Services in the city runs the pretrial program. So the idea is that they would have that direct connection back to the police department. But, Delegate McComas, I actually think that you've raised an interesting question. And so for that reason, I'm going to hang on to this for a second, and I'm going to go back and make sure that this is exactly what the Senate sponsor of the bill would like to do. I'm going to hang on. So I'm going to hold on to it just for a second, and we'll come back to this tomorrow night, because I think that is a valid question. If we're going to do every single crime as opposed to just those crimes that were initially listed in the bill. So I will do that, and I appreciate you pointing that out. Let's go to House Bill 576 then. This is Delegate Juanita Fisher's bill. And it has not got an amendment, I don't believe.
Move favorable.
Second.
Motion for a favorable and a second. Yeah, it doesn't have an amendment. All right, that's fine.
Want me to explain the bill, Mr. Chair, or no?
Why not? There's a motion and a second. Explain the bill. That'll be great.
Okay, sure. So this bill is a cleanup to the electronic wills and trusts, just to simplify it for everyone who maybe is not a will and trust attorney. It does two things. There's a conflict with something called RLONA, which is the Revised Uniform Law on Notarial Acts. So basically this says that people do not need to have it notarized in that way because they have the supervising attorney. The amendment also basically says that with the supervising attorney with an electronic will, they do provide a certification about what's gone on in the will to add a layer of protection. This bill also is now over here from the Senate, 44-0 vote. So it's cleaning it up. There basically was a conflict of law with getting it notarized. So basically, then you couldn't really do an electronic will. And there is a level of protection I know Delegate McComas brought up those concerns. The supervising attorney does have to provide basically a self-proving affidavit about the people that are in the will or estate issue. So that's it. It cleans it up, and Marylanders can do wills and trusts on Zoom.
Move the previous question.
It's awfully quick. All right. Any further questions? I don't see any. There was a motion for a favorable and a second. All right. Seeing no one waving their hands, we'll do a roll call. The vice chair.
Yes.
Shoemaker.
Yes.
Anderson.
Yes.
Erican.
Yes.
Bartlett. Did she leave again? Yeah, we lost her again. Carden.
That was
John.
my daughter.
Oh, are you voting, Delegate Carden? Or
That was my daughter saying yes for me.
okay, Conaway,
Yes.
Cox.
Yes.
Okay, Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams,
Yes.
Bartlett,
Yes.
21 for 576. All right, we're going now to the Carroll County Delegations Bill on the state's attorney. There's no amendments on this bill.
Favorable.
Motion for a favorable, is there a second?
Second.
All right. What the bill does is it says that if you're going to be state's attorney in Carroll County, that you cannot have a law practice, you can't engage in the private practice of law Right now, there are only 3 jurisdictions that allow for the private practice of law outside the state's attorney's office. They are Garrett County, Carroll County, and the city of Baltimore.
Oh, my God.
Anyway,
Can we do a quick amendment to add Baltimore?
okay, this was a local bill. We're not going to do that.
I
But I'm just saying, maybe
Next year.
not a terrible idea. All right. Okay, so we're on 692. Is there further discussion? All right. Roll call. The vice chair,
Yes.
Delegate Anderson. Anderson. Kurt.
Yeah, sure, yes.
Okay,
Chairman Shoemaker.
yeah, I
I'm
believe he's
abstaining.
excused. He's abstaining on this vote.
Oh, he wants to have that practice. Okay,
No.
No, he's running for that office.
I know, and he wants to have a practice.
Presently filed for the office of state's attorney in Carroll County, not in Anne Arundel County.
I was kidding. I was kidding.
Okay. Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
Look, the wavy
Yes.
team.
Crutchfield,
Yes.
Davis,
Yes.
Juanica Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Chetty,
Yes.
Cham,
Yes.
Souls,
Yes.
Williams. Williams? I've lost Williams. I see 20. I'm sorry, I see 19 with one abstention or one person taking the rule.
I see Williams. I vote
Oh, I
yes.
see Williams voting yes. It's back to 20. That's great. All right. Why don't we do what might be the easier bill? Let's see what happens. 1323. We'll go to 1323 now. There are no amendments. This is a straight up technical correction that has not gotten picked up in the corrective bill from Delegate Bartlett.
Favorable.
Ms. Motion for a favorable second.
Second.
All right. So here we are. Are there questions about this? Delegate Erican?
Sorry, could the sponsor just explain exactly what it's correcting and what's the change, like what is that practicable change that's going to happen?
Sure. So essentially, there was an article in the health code that got deleted, but the cross-reference did not. So now what we're doing is fixing to the code to properly remove the cross-reference so that it will make sense. So it got all encompassed in the criminal procedure code. And so now the health code was still being referenced. So now we're just making it so that it'll reference the correct criminal code. Truly technical.
All right. Anybody with any other questions about what has been described as the truly technical bill?
Move favorable.
There's I think we have a motion in the second, but here we have more questions. Delegate Cox.
I'm sorry to belabor it. I know we need to get out of here. I'm
Fine.
just curious.
You're fine.
So the language that indicates that no photograph or information shall be submitted, that's already in the statute. You're just switching it. Is that the way it's?
I couldn't hear your question very well, but it sounds like you might have been referencing the bill that we actually passed before about the photographs or narratives. Can you say your question again, Delegate Cox?
Yeah, there's language that says that you don't need to submit the photograph of the victim or any narrative. That's already in the law, so you just
Right, we passed that, I believe it was last year or maybe the year before, to get rid of, I think it was last year, to get rid of the photographs and the narratives because of the privacy for the victims.
So this is just a curious question. Why isn't this in the omnibus, the annual omnibus bill correcting things? If that's if
Right, and that's what the chair was saying, and that's what the witness Lisa Jordan mentioned. We asked for it to be in the the annual corrective bill, and I can't tell you the explanation because it didn't really make sense, but they said that based on with DLS standards, that this was the best way to do it. I guess, I don't know if Claire or anyone else can explain that better, but that we did say, why don't we just do a corrective, put it in the annual corrective bill? And they said no, because you're actually, I guess, getting rid of, we're doing a full, the cross-reference was referencing something that didn't exist anymore. And so I think maybe because of that, we wanted to have this bill so that it would clearly show that that cross-reference is gone, but it's now in the criminal procedure article. Or as opposed to just saying, see criminal procedure article now, instead of having it like that, because it wasn't just a comma or just something of that sort. It was truly, referencing a section that no longer exists, and we needed to be able to put in the correct criminal procedure article.
okay, well, thank you.
All right. Aren't we glad we took this bill first? We have a motion and a second. Are there further questions on this bill? Seeing none, the vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden.
Yes.
Conaway,
Yes.
Cox,
Yes,
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer.
Yes.
I swear my voice did break. Oh my God. Oh dear. Howell,
Yes.
Rachel Jones,
Yes.
Lopez.
Yeah.
McComas,
Yes.
Shetty. Oh, I'm sorry, Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Foles,
Yes.
Williams.
Yes.
All right. It's been a bit of a long day. We have 2 more to go here. Now we'll do 920. Delegate Bartlett, you want to describe what this bill does, please?
Yes, Mr. Chair. So House Bill 920 essentially it's again, somewhat of a technical fix. We did not include last year medical parole when we voted to remove the governor from the decision-making process of parole. So we're including medical parole. And that's essentially what House Bill 920 does.
Move favorable.
Second.
Motion and a second. All right, is there further discussion regarding this bill? Dylan is bringing me water, because apparently people are concerned about my voice breaking. All right, seeing no further discussion, we'll take a roll call. The vice chair,
Yes.
Shoemaker,
No.
Anderson,
Yes.
Erican,
Yes. I'm sorry. No.
okay, Bartlett,
You can vote yes if you want to, Erican.
My kid is screaming in the background like a crazy person. She distracted me.
okay, Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
no,
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
C. Yes.
Grammer,
No.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
No.
Munoz,
No.
Shetty,
Yes.
Cham,
That's
Cham.
no in German.
9.
Yes.
Sehr gut. Tolls,
Yes.
Williams. She got again?
Yes, no, I'm here. Yes, yes,
Okay,
yes.
14-7. All right, 14-7. Okay, now we have one last one. We are secondary to the Environment and Transportation Committee on House Bill 777. This has to do with the partition of property, partition of real property. Could I please ask Holly, the council is covering this, to talk about the bill, talk about the posture of the bill, please.
Sure. So 777 codifies and clarifies, as Chair said, the procedures for the partition of real property. The language is based on the Uniform Partition of Heirs Property Act, and the bill requires the court in an action to partition real property to determine the market value of the property, establish procedures for the purchase of interest in real property by the co-tenants, and specifies requirements relating to the sale of such properties. According to E&T, all the testimony, everything was favorable. They voted it unanimously. And just some background, this is done in 19 states. Another 7 states are currently considering it, and that does not include Maryland or DC. And it was voted unanimously in E&T after it went through its Housing and Real Property Subcommittee.
The three of us who went over to E&T virtually to be there for the bill were delegates Cardin, Williams, and Shoemaker. I don't know if any of them have any insights they'd like to share.
I thought it was a good bill.
Okay.
There was no opposition.
No opposition.
Move favorable.
We'll do the motion. I see you, Delegate Davis. There's a motion for a favorable. Is there a second?
Second.
All right. Delegate Davis, please.
I'd just like to know what it fixes.
So, oh, go ahead, Delegate. I'll defer.
No. Go ahead, Holly.
Well, I mean, so from what I understand, it just clarifies. So right now, I guess it's not clear jurisdiction to jurisdiction when the partition of real property happens. And it sometimes forces a court sale without notice to the co-tenants. And so it cleans that up to make the notice requirement and the actual value of the property before a court ordered sale can happen. But Delegate Williams, if you have anything to add, please do.
Yeah, I was just going to say it adjusts the valuation of the property. So instead it's based off of the fair market value of the property. They have to get an appraised value as opposed to going through with the assessed value in terms of trying to determine the amount of the property for the partition sale. And then it puts in all these extra kind of requirements to try to ensure that all of the, if it's a co-tenancy, that all the owners receive notice, as opposed to just a one-time attempt at notice.
So the idea, Delegate Davis, I think is, and Holly, correct me if I'm wrong. So we want to make sure that all the people that are interested parties going to benefit from the sale are treated fairly and equally. And so what this kind of sort of a uniform process does is it makes sure that everybody has the best chance of getting the most out of the separation and partition and the sale.
Yeah, Delegate Cardin, that's exactly right. And it gives the chance to a co-tenant, if they want to purchase the property from another co-tenant, they can without if it goes to a court ordered sale, they don't even have that option. And so it sets out those rules. So at least the notice and the purchase can happen before the court ordered sale. Right. And you're right. I guess the uniformity is one of the big things, was just creating some codifying and clarifying the common law so that it's clear across the board. So that, yes.
Delegate Williams, correct me if I'm wrong, because we're going to have to, if there's questions, I want to be ready for it. But if, for example, one of the parties wants to buy from the other party, they still have to go out and get, instead of just taking the assessed value, they have to go out and get a market value so that nobody is exploited if there's an inequality in the different interested parties.
That's correct. Because I think one of the things that we're trying to avoid is situations where, say, an investor approaches one owner of the property and was like, hey, I'll purchase the property for 50,000, because that's what the tax assessed value is, but we know the real value is more like 175, for example, based on the market value. And trying to prevent, investors just kind of come in and scooping up property and then doing a motion to partition to kind of block out the other possible joint tenants or co-owners of the property and them getting less than what they would otherwise get if it was a regular sale of the property.
Okay, thank you.
All right. Does anybody else have any questions regarding this? There's a motion and a second for a favorable. We are again secondary. Seeing no further questions, the vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Sham,
Yes.
Poles,
Yes.
Williams.
Yes.
All right, that was 21. Okay, everybody, I just want to make sure I got one vote correct. Delegate Carden, did I hear that correctly, or was that the yes from your daughter or from you?
Yes, that was a yes from me.
Okay, just check. All right, so tomorrow we have floor at 10 o'clock. The criminal subcommittee will meet at 11:30 or 15 minutes after the floor is complete. I'm not sure that the floor session will be nearly as long as it was today, but who could say? 1 o'clock bill hearings tomorrow, or an hour after, or whatever. The bill hearings will probably be at about 1 o'clock tomorrow. We have 30 witnesses. Then we'll have a vote session tomorrow night, 30 minutes after the bill hearings conclude. For the bills that we passed tonight, House Bills 284 and 296 are Delegate Crutchfield's bills, and she'll defend them on the floor. Delegate Moon for 349, Delegate Juanita Fisher for 576. I'll defend 692. 920 for Sandy Bartlett, Delegate Bartlett, that's what I meant. House Bill 1323 is Delegate Bartlett as well, and E&T will be defending 777. With that, everyone, it has been a day, so we are done. Thank you all very much. We will be back here tomorrow